Now tonight's video is on a little bit more shit fuckery. So it's in regard to the National Measurements Act of 1960. The Department of Justice and Regulation often receives such inquiries and also complaints that a person cannot be convicted of exceeding the speed limit on the basis of a reading taken by a road safety camera unless it can be established that the measurement meets the requirements of the National Measuring Act. The Western Australian decision in Brendan versus Congrass is often referred to as the authority for this position. So basically they're saying a speed camera is not a measuring device. Now, this is where it gets interesting. The Victorian Supreme Court has not followed this decision in Brendan versus Congrass, and that decision does not represent the law in Victoria. Now I wonder why they don't follow that decision. Would there be a contract entered into already? The contract overrides the law. Maybe, just saying. The Supreme Court of Victoria has twice considered the question of whether the National Measurement Act controls the use of automatic detection devices in Victoria. On both occasions, in the case of Mitchell versus Crimpton and Sons Proprietary Limited, and more recently the case of Aga versus Delahoo or whatever, Delaguy, Supreme Court has determined that the position of the National Measuring Act does not apply to speed cameras. Well, that's interesting, isn't it? That's really bloody interesting. And I wonder why that is. Possibly something to do with a bit of shit fuckery. So, you've just got to be really careful with the contracts that you enter into. Because once you enter into a private arrangement with like a corporation or something like that, there's probably no real remedy. And that's why they're saying that the National Measurements Act doesn't apply. Right? Because it's all inequity. It doesn't matter. National Measurements Act is therefore irrelevant to the prosecution for speeding based on the speed camera evidence. Whatever evidence is, like the speed camera's getting up on the stand and giving evidence, is it? That's interesting. Don't accept the speed cameras as evidence because it doesn't comply with the National Measurement Act. Victorian Road Safety Camera Commissioner also considered the issue of his 2011-2012 annual report and found that the decision of Brendan versus Congrass is contrary to the decisions of the full court of the Supreme Court and the Supreme Court of Victoria. Now, furthermore, your correspondence is based on a template of a well-known booklet, and I never knew that. I thought I just made up a bit of shit fuckery and wrote it back to him. So that's interesting, but it doesn't actually say what well-known booklet I may have been referring to. Because I don't think I did refer to any booklet. To offer advice on means of avoiding traffic infringements. The Department of Justice and Regulations, which has received many similar letters in the past, does not accept that arguments raised in your correspondence undermines the successful prosecutions of traffic infringements. And there you have a bit of shit talk right there. So they're talking shit to try and enter you into a contract. Okay, so now, a little bit on the previous page. The process that you should follow to discharge this matter lawfully is clearly explained on the front of the infringement notice. Your current approach will not finalise any outstanding matters. Well, that's interesting, because I don't think they want to talk to me anymore. I'm happy to talk to them, but they just don't want to talk to me anymore. So, I would say I think all my matters have been finalised. Apparently they had like 3 warrants, none of which they could actually send to me, none that were in the correct format. So enforcement warrants. They couldn't actually produce them, but they said they had them. Now that's interesting, isn't it? Alright, don't put up the shit fuckery. Cheers, people. Bye.